Hi, everybody. This is Samantha from the Law Offices of Samantha Wolfe, and today I'm here for this month's virtual seminar. I'm excited about it. I'm going to go ahead and share my screen so that we can pull it up. And today, we are talking about It's All About Deeds, titling differences and their estate planning implications. I have to tell you, I enjoy doing these virtual seminars. It allows me to really focus on different topics and talk about different areas. So I hope that you enjoy them as well. You can always check out our YouTube channel. We're always uploading new videos, trying to keep the content fresh and trying to break it down into smaller segments so that if there's a specific topic you want to hear about, that we're covering that in maybe a shorter video as opposed to our long virtual seminars. So today, distinct pleasure to talk about It's All About Deeds, titling differences in their estate planning implications. Thank you so much for joining us. We like to do these seminars as part of our mission statement. We feel like it's really important to be able to get out information to our clients, to our referral sources about different areas of the law, different things that we like to talk to clients about. So that's why we do these virtual seminars. So let's start by talking about what are the different ways that you can title a deed. So we have four main ways that we typically run into at our office. I'm going to focus on these four. There are different ways that you can title deeds, but these are the ones that we find most often in our office. So we have tenants in common, joint tenants with right of survivorship, tenants by the entireties, and a life estate. We're going to go through each of these and talk about them, but I wanted you to know that these are the main four ways in our office that we see deeds titled. So tenants in common, we're going to start with that one. And the reason why we're starting with this one is that in Pennsylvania, this is the default in Pennsylvania unless the deed has particular language saying something different. So tenants in common is where it's an undivided ownership between two or more people. Different people can own different percentages. So I can own 60, my sister can own 40%, or it could be that there are three of us and we all own it in 1/3. But again, it can be different percentages. The owners don't have to own it in an equal share. That's what's important about tenants in common. Again, if the deed is silent, then the default in Pennsylvania is that you own it as tenants in common. And when the owner dies, your share, the owner's share, goes through his or her estate. So in the example at the bottom, if I own half interest and my sister owns a half interest and I die, my half is going through my will. It doesn't automatically go to my sister with tenants in common. It may limit the inheritance tax because if my sister and I are on the deed and title doesn't automatically vest in her, if it goes through my will and my will says it goes to my husband, then it's going to be 0% inheritance tax, where if it went to my sister as the joint owner, then there would be inheritance tax at a rate of 12%. So when you own it as tenants in common, it goes through your will. Depending on who's ultimately going to receive your share of that real estate, it may limit Pennsylvania inheritance tax. It may result in probate because in this example, if I own half and I pass away, in order for my executor to be able to transfer my 50% to my beneficiaries under the will, the executor has to get appointed by going through the probate process. Another important thing about tenants in common is all tenants are liable for the debts and taxes. So again, we don't really shift the share of that. Normally, we're both liable for it. We both need to pay our share. Now, it is subject to the DHS Medicaid recovery lien. So that would mean that if I go into a nursing home and I die while I'm in the nursing home and my half of the property is going through the will, then that means that DHS could try to recover against my 50% share, which might mean that my sister has to sell it in order to be able to pay off that lien. And the example that we have there is if I own, Samantha Wolfe, if I own half and then my sister owns the other half, we could own it as tenants in common. And when I die or when Jess dies, that person's share goes through their estate. That's tenants in common. And again, the important thing to know is that in Pennsylvania, that is the default unless the language states something different in the deed. The next way that you can own property is joint tenancy, and typically we see this joint tenants with right of survivorship. So the example would be Samantha Wolfe and Jessica Blair as joint tenants with right of survivorship. Now there has to be the four elements are needed, meaning interest, possession, time, and title. So each owner must have the same interest in property. So if it's going to be Jess and I owning it, that means that I own half and she owns half. If there are 3 owners, that means that each of us own a 1/3 share. It has to be equal ownership. All owners must own an undivided equal interest. All owners must receive their interest at the same time. So for example, Jess and I would have had to receive our joint tenants with right of survivorship in the same deed. If I then try to transfer my half interest, that severs the joint tenancy. And once it's severed, you don't get it back unless you do a deed where the individuals get it at the same interest, possession, time, and title. All owners must acquire their interest with the same deed if you own it as joint tenants with right of survivorship. At the death of the owner, property automatically vests in the joint owner. So in this case, if I die, Jess automatically gets my 1/2 interest, which will mean Pennsylvania inheritance tax may result because as my sister, Jess is going to pay a 12% Pennsylvania inheritance tax because she received my interest in the property. Does avoid probate though. Jess automatically gets my half interest. It doesn't have to go through my will. No executor needs to get appointed. And it does avoid the DHS Medicaid recovery because it doesn't go through my will. Jess automatically gets the title if I would pass away. The next type, the third way you can own it, is tenants by the entirety or tenants by the entireties. That is specific ownership between a married couple, and you have to be married at the time you acquire it. So if you have 2 people who are not married and they own something, they purchase something, and on the deed it has both of their names, they do not own it as tenants by the entirety, even if they get married after. They would have to redo the deed and say that we now own it as tenants by the entireties. So the default for a married couple is that it's owned tenants by the entireties. Property may not be sold without the agreement of both parties. So a lot of times in our deeds, it'll say that the spouse is going to sign off on it. So that's really important. Now, if a spouse dies, so if we have a husband and wife and the husband dies, the wife does not need to redo the deed at that time. If and when she ever sells the property, what we'd put is we would put a clause in the deed that says the husband died on this date, and when he died, title vested in the wife. And as a result of that, she can sell it and be the only one to sign off. Or perhaps she dies and then the executor sells it. So at the death of the first spouse, the interest vests in the surviving spouse. It is the default for married couples, as long as they were married at the time they acquired the property, unless the deed states differently. It does avoid the DHS Medicaid recovery lien because when one spouse dies, title automatically vests in the surviving spouse. And it does avoid probate. Those deeds do not need to be retitled. I get that question a lot from the surviving spouse. Do I need to do a new deed now that my spouse has died? No, you do not. You don't need to do the new deed unless you're selling it, because while you're living, you're selling it, or when the second spouse dies, if the estate is going to be transferring it. At that point, we would just reference when both spouses died. The example of that would be Josh and Jess Blair. My sister and her husband can own it as tenants by the entireties. One of them dies, title vests in the surviving spouse. Okay, the last type of deed we're going to talk about is a life estate deed. So this is an interesting type of deed. This allows the owner to use the property while he or she is still living, with the property automatically transferring to the remainder beneficiaries at the death of the life tenant. It does avoid probate because what happens is you're going to say, Samantha Wolfe during her life, and then at her death, title vests in Jess Blair. And so it does avoid probate that way. Now, Pennsylvania does have an applied life estate for inheritance tax purposes, meaning that if I try to transfer my home to someone and I still live there without paying that new owner taxes, Pennsylvania is going to say that's still my home, and so there's an applied life estate. So even though the deed doesn't have the life estate language in it, Pennsylvania is going to apply the life estate doctrine to that deed. Now, it does protect the rights of the life tenant to reside at the real estate, which sometimes can be really important if mom or dad wants to transfer their house to their children, but they still want to make sure their kids can't evict them. Then a life estate can be really important. There's no risk for a DHS Medicaid recovery lien because it doesn't go through the probate estate, because it'll say when the life tenant dies, title vests in the remainder beneficiaries. But As a result of that, the remainder beneficiary must sign if there's ever a sale of the property. So sometimes our clients don't like that. They like that they reserve the right to live there while they're living, but they don't like that the remainder beneficiaries have to sign off on the deed if they ever want to sell that property. Real estate is subject to the creditors of the remainder beneficiary because their name is on the title. And property taxes are the responsibility of the life tenant typically, but they don't have any control because it requires the remainder beneficiary to sign off if there's a sale. So you want to make sure you're weighing the pros and the cons of the life estate and make sure that is truly what you want. Sometimes we have clients that do a life estate and then they actually extinguish the life estate if for whatever reason they don't want to live there anymore, they don't want the life estate. So you can extinguish it at some point in the future if you reserve it initially. But we do have some clients that reserve a life estate. I would say more of our clients though do use a trust than utilize the life estate as a planning technique. And that's just because I think a trust offers more protection against the remainder beneficiary creditors and concerns if the remainder beneficiary dies. The trust is a little bit more secure. So that's usually I talk to clients about that and they tend to err on the side of caution and want to make sure that they're protected. But a life estate deed is a way that you can transfer title. Let's talk about adding children to the deed because that is probably the most frequently asked question that I get is, should I add my children to the title of my deed? And the benefit there is it transfers ownership, and automatically when the mom or dad dies, you don't have to probate, title automatically vests in the children. And that's usually why the client's asking, because they don't want it to go through the probate process. So they'll ask about that. And it does allow your child to reduce inheritance tax, Pennsylvania inheritance tax, unless we're talking about the life estate. So again, if you try to transfer it completely to your kids and your name isn't on it at all, but you're still living there and not paying tax on it, then Pennsylvania is going to assess Pennsylvania inheritance tax because there's an implied life estate. But for most people, they might just add their children on as a joint owner. And if that's the case, then potentially it can reduce the inheritance tax. Depending on the type of property, if it's a non-residence, if it's a rental property or an additional piece of property. But what you have to remember is that there's always a tax consequence when you're avoiding one type of tax. So if you avoid the inheritance tax or reduce the inheritance tax, what happens is your child gets carryover basis. Carryover basis is whatever you purchased the property for, whatever your investment in the property. So if you're trying to avoid inheritance tax, it means that the children or your beneficiaries get your basis in the property. And if they're planning to sell it when you pass away, that may mean more capital gains. So sometimes it's better for the kids to pay the inheritance tax at a rate of 4.5% because then they can avoid the 15% capital gains tax. Another advantage of adding your children to the deed is it does avoid the DHS Medicaid recovery lien because it never passes through your will. That means that the nursing home can't try to recover the cost of care against the value of the house. But those are some pros, but I think the cons outweigh it. So the downside of adding your children to the deed is that your home could be exposed to your children's creditors, divorce, car accident, anybody suing your kid. All of a sudden, your home is subject to that child's creditors. It also might affect qualification for Medicare, student loans, and more. And if your finances are complex, it leaves both you and your child vulnerable to foreclosure and other concerns. And then if your child is on the deed and they predecease you, then you have to worry about inheritance tax on your own house. So a lot of times clients don't like that. Why would you want to pay inheritance tax on your own house that you've already purchased? And then you want to think through the Medicaid rules. So if you add a child to the deed, it is considered a gift for Medicaid purposes, and it is subject to the 5-year look-back period. So at our office, we will talk about adding children to the deed and explore and talk about the pros and the cons, but most of our clients opt not to do that because a trust can be a better option. It offers more protection for both our client and the children, and we don't have to worry about the carryover basis and the inheritance tax and those concerns. We want that step up. And so if we put it into a trust, the kids will pay inheritance tax, but then they'll get that stepped up basis. So then they won't have any capital gains when the property is sold. So a lot of times our clients opt for that as opposed to doing a situation where they add their children to the deed. I like it. It's more secure. So that's what a lot of our clients do. Now let's talk about deeds on death. So we always like to verify how the title was. And again, if it's between spouses and one spouse passes away, you do not have to redeed the property. You want to check the deed because you want to make sure that it doesn't have to go through the probate process. But if it's owned between spouses or if it's owned joint tenants with right of survivorship, when one person dies, it does not go through the estate. Now, for valuation purposes, to determine what the inheritance tax would be, you can get an appraisal. Or if you're selling the house, like on the market using a realtor, using an auction house, usually we'll just use the sale price, because if we pay inheritance tax on that value, that's the stepped up basis and there's no capital gains. So we do use that as another way to do it. Usually it's an appraised value, or if it's whatever we're selling it for. Sometimes clients aren't planning to sell it, and so they'll use the tax assessed value times the common level ratio factor for the county where the real estate is situate, but that's usually a lesser value than what it would actually sell for. And the problem with using that lesser value is it may mean more capital gains tax when the property is actually sold. So that's why we typically use the sale price or the appraised value. And that's just what we're talking about. You want to weigh the inheritance tax for children, which is typically 4.5%, which is versus the capital gains tax, which is 15%. Here are some hypotheticals, some examples. So if we have John and Jane Doe and they transfer it to Bobby Joe, Mary Joe, and Thelma Joe, in this case, they're owning it as tenants in common because each of Bobby Joe, Mary Joe, and Thelma Joe own it as a 1/3 undivided interest. So if either or any of them, any of the three of them pass away, their 1/3 is going through their estate, through their will. It doesn't automatically vest in the surviving owner. So it does mean it's subject to probate, may mean less inheritance tax because it's not going to siblings where there might be a higher inheritance tax. Hypo number 2 would be John and Jane Doe to Rebecca Smith and Donald Clay. And in this case, they own it as joint tenants with right of survivorship. So what that means is if Rebecca passes away, title vests automatically in Donald, or if Donald passes away, title vests in Rebecca. And you just want to make sure you're thinking through what does that mean for inheritance tax purposes? Because if they're siblings or cousins, it might be 12% or 15% inheritance tax. So you just want to make sure that you're thinking through that. Hypo number 3 is Autumn Fall, who's a widow, and if she titles it as Autumn Fall as a life tenant and then Summer Fall as a remainderman, then when Autumn passes away, title automatically vests in Summer. So this is a life estate deed. And again, it could be that if Autumn is living there, it's her primary residence, it's going to get all pulled into her Autumn's estate, which would mean it's 100% tax for inheritance tax purposes, but then Summer gets the 100% stepped up basis, so less capital gains tax in that situation. Okay, so we gave you the example of the life estate, joint tenants with right of survivorship, and then the tenants in common. The only one we didn't give was the tenants by the entirety, and again, that would just be a title between husband and wife, and the default, even if it doesn't say it is, it's tenants by the entirety. I hope this brief exploration of titling and deeds was helpful. If you have questions, you can always come visit us at our office at 20 East 6th Street, Suite 206, or you can call our office at 717-655-2676 to schedule an initial consultation. We'd be happy to chat with you. And you always check out our YouTube channel. We do try to update it with our virtual seminars every month, so be sure to check out that. All right, thanks everybody. Have a great rest of your day. Bye-bye now.